The broadcast is now starting. All attendees are in listen-only mode.
Welcome everyone to Nova 401k Associates webinar, Long-Term Part-Time Employees, Are You Prepared? With Craig Hoffman. Before we get started, I'd like to point out the panel on the top right-hand corner of your screen. You will see a drop-down section for questions or chat. This is where you'll enter in any questions you may have for Craig. Please keep in mind that the Q&A portion will be held at the end of the session, and he will answer as many questions as time permits. If time runs out and you still have questions, you can send them to our email address, webinars@nova401k.com, and we can go ahead and forward those over to Craig. Right below questions and chat, you will see the handouts drop down. Here you will be able to download today's material. If you are with us today to earn continued education credit, please be sure to stay until the session ends to fill out the pop-up survey. This will allow us to track your time and participation. Certificates will be sent out within a week for those who met the time requirement. To view any webinars you may have missed and the recording of this session, you can follow us on our YouTube channel, which is Nova 401k Associates, or visit our website, which is www.nova401k.com/webinars. Thank you for joining us today. I would now like to introduce Nova's attorney and senior consultant, Craig Hoffman.
Thank you, Yvette. Good afternoon for those where it's afternoon. A few of you are still finishing up the morning. Welcome. We're happy to have you at our continuing series of Nova webinars. It's my pleasure to do an update really on long-term part-time employees, particularly after Secure 2.0 and the impact it will have as we prepare for implementing this next year. But the normal disclaimer, this is not tax advice, it's just a seminar. Get your own lawyer. If you need CPA credit, I'm not sure if this is just Texas, but you can check with Yvette if you need CPA credit, and the provider number is, I think this is nationwide. This is me. You can read all about all the stuff I've done over the last 40 years. It's been a lot of fun, but that is me, and if you've been at a recent webinar I've done, you know my life has markedly changed over the last year. We brought a new member into the Hoffman family. Fergie is a mini golden doodle, a little over a year old. She has been a great pleasure, and I thoroughly enjoyed taking her to the dog park. And so I don't have any grandkids yet. As soon as I get them, they get first dibs on a picture, but for now, this is my youngest child, Fergie. All right, what are we going to talk about? We'll begin with some background. We'll talk about the Secure Act changes, both 1.0 and 2.0, and then we'll delve into the details of how it works with regard to eligibility, contributions, non-discrimination, vesting service. We'll talk about amendment deadlines, as well as some concerns. There's another bullet I missed in there, some alternative plan designs we'll talk about as well. So we've got a pretty full hour to get through, so let's begin at the beginning. Congress has been concerned for some time that gig workers or long-term part-time workers were not getting access to workplace retirement savings plans. And studies over the years have shown you're 14 times more likely to save for your retirement if you have a workplace savings arrangement rather than having to do it on your own through an IRA. And so the thrust of this policy change in Secure 1.0 was to try and give those folks who might not otherwise meet the traditional year of service the opportunity to participate in their employer's 401k plan. The problem with Secure 1.0, oh, missing a space there, it was this provision that came in for long-term part-time workers. Now, 1.0 had floated around Congress through several iterations, and it was only the very last version that included coverage for long-term part-time employees. It had not been well vetted, and so there are some glitches, one might say, in how this law was written, but some of them have been fixed in Secure 2.0, but we need some help from the IRS with guidance to figure out some of the issues, but I'll hit upon them and when we expect the guidance to be out, which should be any moment. I checked this morning, it wasn't out yet. So what did 1.0 Secure amended the 401k rules to add a new subsection 2D that requires, as a condition of being a qualified cash or deferred arrangement, that any employees who have completed either actually, I'm sorry, I was trying to update this. I now just realized employees who have completed either 3 or 2 consecutive 12-month periods in which they were accredited with at least 500 hours of service. So it's 3 initially, it's going down to 2. And I was updating this PowerPoint and I put in the 2 and must have knocked out the 3 accidentally. I apologize. We'll go through this in greater detail. This is really just a summary. So it became effective for plan years beginning after 2020, which means it's been in effect for over 2 plan years now, but you did not need to credit service before January 1, 2021. So this effectively means the first long-term part-time employee will not need to join the plan until January 1 of next year. But Secure makes further changes. It reduces the required of 12-month periods with 500 hours of service credited from 3 to 2. And that's what should have been on the first slide. So it was 3, it remains 3, but for plan years beginning after 2024, it will drop to 2 consecutive 12-month periods with at least 500 hours of service. In addition, Secure 2.0 adds this as a mandate for 403B plans, but only those which are subject to ERISA. And that is effective for the plan years beginning after 2024. So 403B plans don't have to worry about this until 2025, but the time to get prepared is now. The Secure 2.0 also added provisions to mirror these rules under Title I of ERISA, the labor provisions, and made 2 retroactive technical corrections. One was very important. It allows service credited before January 1st of 2021 to be ignored. You don't have to credit that service for not only eligibility, but the technical correction made the same rule applicable to vesting service. And it also made sort of a technical change that you can still qualify for the top-heavy exemption for a safe harbor plan, even though the long-term part-time employees do not receive safe harbor contributions. So how does it work? Eligibility. First and foremost, the new law does not require an employer to adopt a plan. It's only employers who choose to sponsor a K plan or 403B plan subject to ERISA that must comply with these requirements. They don't apply to simple IRAs. They don't apply to 457 plans. But as I said, they apply to 403B plans only if they're subject to ERISA. So that would have, beginning in the 2025 plan year, to be very clear, this takes effect in 2025, whereas the 401k rules were already effective in 2021. So examples of 403B plans not subject to ERISA would include governmental sponsored 403B plans, which is very common in public school employees, public colleges. It's also available, the exemption applies to non-electing church plans. And then there's a third election that's based on facts and circumstances. These are plans where the employer's sole involvement is limited to collecting by payroll deduction employee contributions to the plan. And there's a DOL reg that goes through what that means for lack of employer involvement. But one of the mandates is that participation has to be entirely voluntary by employees. And so the concern is in a mirror provision that takes effect beginning with the 2025 plan year is the mandate for automatic enrollment. So, and that applies to both 401k and 403b plans. And we will wait to see whether the DOL amends their regulation, but at least under the current regulation, if you've got a 403b plan with automatic enrollment, it does not qualify for the ERISA exemption. So going forward, it may be much more difficult for a charitable 501c3 organization to qualify as not subject to ERISA under that exception. But generally speaking, at least for now, 403b plans subject to ERISA are the ones that should be filing and must file Form 5500. So they should be fairly easy to identify. Now, a long-term part-time employee is defined as one who is credited with at least 500 hours of service during either 3 or, beginning in 2025, 2 consecutive 12-month periods. The normal eligibility computation rules apply such that your first 12-month period begins on the date you're hired, and subsequent 12-month periods begin on the anniversary date unless you have an election in your plan, which switches the eligibility computation period to the plan year if you don't have 1,000 hours in your first 12 months of employment. That's very common. We do that because it then puts the eligibility computation period on equal footing with the vesting computation period, which can be the plan year all along. And so that's very common. But if you apply that to the long-term part-time employee rules, you may well find that you are bringing in these long-term part-time employees as of a period much shorter than 3 or 2 years. So that the period could be as few as 25 months rather than 36, or when we go to the 2-year period, 13 months. And we'll go through a case study illustrating so you can see how this can be problematic. And generally speaking right now, this election is made for all your eligibility computation periods, and sure, it will be permissible to have or even if it makes sense to have a different eligibility computation period for long-term part-time employees versus full-time employees, because you're still going to have to plot 1,000-hour years in case the long-term part-time employee earns the right to enter the plan full-time employee. So again, we're now here in March. Decisions will need to be made, at least operationally, and ultimately reflected in the plan document. Certain long-term part-time employees may be excluded. Those who haven't attained age 21, those covered by a collective bargaining agreement where retirement benefits were the subject of good faith bargaining, and non-resident aliens with no U.S. source income. Remember, it's not just a non-resident alien. That person must not have any U.S. source income, which typically, if the non-resident alien is resident in the United States, they're going to have U.S. source income. So it's typically applicable to non-resident aliens of a company, say, based here or with a plan in the United States, but are working overseas and never set foot on American soil. The normal entry rules apply, so you've got to enter the plan no later than the earlier of the first day of the plan year, or the first day that is 6 months after the date on which the employee satisfies age in service. And as is typical, most plans have dual entry on January 1 and July 1 to satisfy these rules, and that type of entry system will work equally well for long-term part-time employees. So here's the case study I mentioned. Billy's Bicycle Shop has a calendar year 401k plan that requires a year of service and attainment of age 21. In 2021, Billy's 401k plan, as required by Secure 1.0, began complying with the new rules for long-term part-time employees. So Lance, who was 49, began as a part-time employee. He was looking to keep busy after giving up his main profession with bicycling, and decided to work at Billy's. And as a result, he's hired December 30th of 2021, and he keeps working every month for the next 36 months and has credited with 600 hours in each of those months. So we've now got Billy at the December 30th, 2024, as having completed 3 consecutive 12-month periods in which he was credited with 500 hours or more of service. If the plan uses semi-annual entry, when would Lance be eligible? Well, let's assume the plan does not switch to the plan year for the second eligibility computation period. Well, then it's pretty easy. As I just said, he completes his first 12-month period on 2022, the second December 29th, 2023. No, he was hired in 21, 22, 23, and December 29th, 24 is when he completes his third 12-month period. He must enter by the first day of the plan year. Following that, that's the closest date. So bingo, he comes in 1/1/25. But what if we elected to switch the eligibility computation periods? Well, then his first 500-hour 12-month period ends December 29th, 2022. But then his second one will be the plan year ending within his first computation period, which just happens to be calendar year 2022. So at the end of calendar year 2022, he's got his second 12-month period. At the end of calendar year 2023, he's got his third 12-month period of 500 hours or more. And bingo, he's now entering a full year earlier than if we had not switched the eligibility computation period. You know, move the dates up a few years, and we had a 2-year eligibility. He would be getting in basically by January 1st, after being hired on December 31st of 2021. He'd get in January 1 of 2023, by switching when we move to 2 years of service. So certainly something that should be considered by plan sponsors, and we need guidance again from the IRS and maybe even DOL on this issue. Now, we talked about who can be excluded. There's a big question mark out there that we have been debating, frankly, amongst the pension nerds I hang around with, about whether the long-term part-time employees override the ability of an employer to exclude a class of employees from eligibility, which employers do all the time as long as they can otherwise pass discrimination testing. So, for example, it's not unusual for a company with Division A, B, and C scattered in Des Moines, New York, and Florida, and it turns out Division C employees in Florida are not eligible to participate in the AB plan. Can they do that? Sure, as long as they can pass coverage and non-discrimination, and depends on the makeup of the demographics, but that happens all the time. Well, what happens if you've got long-term part-time employees working in Division C in Florida? Do they have to get into the AB plan because it's sponsored by that employer, the same employer that's employing the long-term part-time employees in Florida? The answer is, we don't know. My personal opinion, think you should be able to do that, but we don't know. One thing I would say, though, that is for sure, that if we are permitted to use a classification exclusion, it must not have the effect of indirectly imposing an age or service condition as prohibited by the Reg 410A-3E1. So that, for example, if a company has 2 divisions and to work in Division B, you must have at least 5 years of experience in Division A. So the only way you get to be an employee of Division B is by working 5 years in Division A. Now, if you set up a plan in Division B and say none of the people in A are eligible, what you've done is indirectly impose a 5-year service eligibility requirement. That's not permitted. But I think if you're excluding Division B and it's representative demographic and there's no service conditions associated with that, I think you should still be able to do it, but we'll have to find out. This now plays out, though, into 403B land, which, again, has just been added to the mix by Secure 2.0. But the 403B rules, the universal availability rules, require you to make elected deferral contribution option available to all employees if you make it available to one. However, there is written into 403B two exemptions, two exclusions from the universal availability rule. One is for basically grad students. The second is for employees who normally work less than 20 hours per week. I think the long-term part-time employees will trump the exclusion for workers who normally work less than 20 hours per week. I do not think it should trump the exclusion for student employees in colleges. It's upper division student exclusion. And we'll have to find out, but it seems to me that the student exclusion should not be considered to be a service-based classification, whereas the 20-hour rule likely would be and would be impermissible. But again, how many times have I said, please, IRS, give us some guidance? I've got it at various places in the slide, but I'll throw it in right now. We've been begging for it since Secure 1.0 was signed in 2019, all through 20. IRS said they're working on it. In the spring of, may have been even the fall guidance plan, the IRS expected to have the long-term part-time guidance out by May of 2022. That's almost a year ago. It keeps being moved back. It was last due out in January of this year. Obviously still not out. It could drop at any moment, and we needed to answer some of these questions sooner rather than later. So how does it work for contributions? When a long-term part-time employee becomes eligible, he or she must be given the option to make elective deferral contributions to the employer's sponsored 401k or 403b. It does not require the employer to make any other contributions. But one point I did mention already, and that is beginning in 2025, it is going to 401k and 403bs are subject to auto enrollment, and I see no exception for long-term part-time employees having to be subject to that same auto enrollment. The one exception, obviously, for auto enrollment is one for plans established before December 28th. Actually, plans established before December 28th are the ones who are subject to this new rule, or excuse me, are not subject, are grandfathered. So if you were established before the date of enactment, which was December 29th, you're good to go. Actually, the number's right. It was December 29th. I'm confusing myself. So plans established after 12/28 have to have auto enrollment unless it's a small employer who normally employs 10 or fewer individuals, new businesses in existence for less than 3 years, church plans, and governmental plans. So the auto enrollment feature, as I already mentioned, is likely to make ERISA coverage mandatory unless DOL regulations provide an exception. So unless you are exempted from auto enrollment, such as being a governmental or a church plan, you're probably going to be stuck with it as an ERISA plan and subject to the long-term part-time employee rules. As I mentioned, the employer is not required to make any matching or non-elective contributions for long-term part-time employees, even if they're making them for everybody else. With that said, if the employer wishes to make contributions on behalf of long-term part-time employees, they are welcome to do so. Long-term part-time employees are not required to receive top-heavy minimum benefits, which is good. But I would also add, finally, Secure 2.0 allows us to disaggregate, if you will, otherwise excludable employees from being required to receive a top-heavy minimum contribution in defined contribution plans beginning next year. So that'll make it easier, or I guess more attractive to an employer to open up the plan to folks who haven't completed a year of service. And we'll talk a little later, that might be a design alternative to avoid these rules entirely, but we'll come back to that in a little bit. But that's a very welcome change that's been sought after for some time. If the sponsor does choose to make contributions for the long-term part-time employee, you don't have any adverse effect on your testing. You can disaggregate them or disregard it, rather, you don't even have to test them separately. You disregard them for non-discrimination, coverage, ADP, ACP testing, safe harbor contributions, and top-heavy minimums. But and it's possible, it's permissible. If you want to include them in your testing, you can, but it's unlikely. I believe unlikely to help you, but more likely to hurt you in your testing regimes. If a long-term part-time employee eventually does complete a year of service, then he or she will no longer be able to be disregarded as a long-term part-time employee when you're doing your coverage and non-discrimination testing. They must be eligible under the terms of the plan to receive contributions like anybody else who's completed a year of service, and they would be entitled to top-heavy minimums. However, one thing that doesn't change is vesting, which is what we're segueing to. Although, again, you're not required to make contributions. If you do, then the normal vesting rules, or vesting schedule, I should say, will apply. But even if the employer says, I'm not putting a penny in for long-term part-time employees, so I don't have to worry about vesting because all their elected deferrals are 100% vested, well, that doesn't necessarily work, because at some point in time, that long-term part-time employee may in fact qualify to enter the plan after completing a year of service, and by doing so be entitled to contributions, and therefore those contributions are likely subject to the plan's vesting schedule. So vesting is going to be an issue, even if you're not making contributions on behalf of long-term part-time employees, because it's likely a few of them at some point in time will enter the plan as a regular participant. There are different rules that apply to long-term part-time employees, at least how many hours they need for vesting credit. They only need at least 500 hours in a year to get a plan year, or the vesting computation period. They need only 500 hours to get a year of vesting credit. And these rules, these special vesting rules, only apply to employees who are eligible to participate solely by reason of being a long-term part-time employee. The rest of the employees continue to vest under the normal 1,000-hour rules. However, vesting, if and when that long-term part-time employee does become a full-time participant, their vesting credit, nevertheless, for all eternity in that plan, must be based on the at least 500 hours of service standard. So that means the long-term part-time employee is going to be favored and get vesting faster than employees who enter as full-time employees. And again, this, as I mentioned, it's not clear why Congress carved this out. This bill was not well vetted by stakeholders such as ASPA and other interested parties who normally engage with the Congress when they're working on a draft of a bill to try and iron out some of the glitches. So it's not why that exemption, or it's not clear why Congress continues this requirement even after you become long-term part-time, but they had a chance to fix it if they intended to and secure 2.0, and they didn't. So I'm afraid we're stuck with that. IRS issued Notice 2068 to provide interim guidance with regard to the Secure Act provision. It answered some questions. The one hopeful point is it asked for comments on how to reduce the administrative burdens caused by the new law. And that guidance was, as I mentioned, was due in May of 22, was due out in December of last year. To date, nothing's been updated on the guidance plan and nothing has been released. The administrative burdens, though, in 2020 were greatly alleviated by Secure 2.0, because one of the problems was in 1.0 was that vesting service before January 1, 2021 had to be counted for vesting purposes. And that was going to be very difficult. And thankfully, Congress listened, and as part of the technical, it was made a technical correction as retroactive as if included in Secure 1.0, that for both eligibility and now vesting service before 1/1/21 can be ignored. So that greatly eased our administrative concerns with regard to trying to figure out credit based upon, plan records going back 10, 20, 30 years potentially. The 1.0 did not specifically address what computation period to use for the purpose of vesting credit, because the vesting computation period rules and the eligibility computation rules are in the DOL regulations, because under the ERISA reorg plan number 4, DOL has jurisdiction over those areas of ERISA. So they're the ones who write the regs. And we didn't have any ERISA provisions for this when 1.0 was enacted. Well, we got ERISA provisions for 2.0, but they screwed it up. What else can I say? The 2.0 ERISA provision says the vesting computation period must be determined using the eligibility computation period rules in 202A3A. Vesting is in 203, I think, A3A or A2A. In any case, 203A3A, I got it right. And so what that means is your vesting period for long-term part-time employees apparently will have to be based on your initial date of hire and 12-month anniversaries, which is, bonkers. We can hope this is corrected. ASPA is aware of it. I know they are talking to staff. The real question is whether we get any technical corrections billed this year. There's a good chance, given the other glitches in Secure 2.0, but for now, this is problematic, and I don't know what to tell you in terms of what it means when we start administering these plans, these people beginning in 2024. As I mentioned, there are some plan design alternatives, and this is one that is being debated as to whether it really is or is not a design alternative. And the design alternative is let everybody in before they would ever qualify as a long-term part-time employee. The idea is that many plans allow people to participate, at least make elected deferrals, the first day of the month following their date of hire or something such as that. And the question, those people get into the plan not by reason of being classified as a long-term part-time employee. And it would seem to me pretty straightforward that if that's your eligibility conditions and people get in first day of the month after hire, then you're not subject to these rules. And a plan sponsor may well want to consider changing the eligibility requirements to go ahead and permit employees to make elected deferrals before completing a year of service, and then you don't have to mess with any of this stuff. So if you allow everybody in, it would avoid the need to apply the special vesting rules. You would avoid the need for, special eligibility computation rules. You would not have to you would not need to credit service under the 5-hour rule, and IRS guidance will need to confirm that this is the proper interpretation of the law. If they are permitted to defer before a year of service, it should not, particularly beginning next year, detrimentally affect our plan design, because those employees would be considered otherwise excludable that could be disaggregated for purposes of coverage testing. You could disaggregate them for purposes of ADP, ACP testing. If you've got a safe harbor plan, you can disaggregate them from the safe harbor contributions. The one glitch that applied to this has now been fixed by Secure 2.0, because now we don't have to make top-heavy minimum contributions in defined contribution plans for otherwise excludable employees beginning in 2024. So I think this is a very valid plan alternative design. Some of my colleagues are not sure the IRS will agree to this. And I just am kind of, I don't understand how they can think otherwise. They're being conservative, and again, this is only my humble opinion, but I think that should avoid these rules entirely, and certainly something that might otherwise be considered. Now, the fact of the matter is, you might need to act right now to let these people in before we get to the completion of 2 consecutive 12-month periods with 500 hours after, or 3 consecutive 12-month periods after December 31 of 19 of 20, so that the bottom line, because otherwise they may be getting in as a long-term part-time employee. So consideration. So let's take a look at a case study. Central Park Coffee Shop has a 401k plan. It was established 1/1 of 2011, so it's been around for some time. Year of service, age 21, biannual entry dates. We have also discretionary profit, discretionary match for employees who enter other than as long-term part-time employees, and employer contributions are subject to a 6-year graded vesting schedule. And who are our participants? Well, we've got 3 part-time employees, Rachel, Monica, and Phoebe, who were all hired on the very same day. They came downstairs from their apartment and signed up beginning January 1, 2018, and have worked there ever since. You can see before you their hours of service over the years. And the question is, when do the new long-term part-time employee rules apply to the Central Perk Plan? Plan years beginning on or after January 1 of 2021. Assume service credited before 21 is not counted for long-term part-time eligibility purpose. What is the earliest date? Anybody enter? January 1 of next year. All right, who of Rachel, Monica, and Phoebe might enter the plan next year? Or better yet, when will they enter? Well, Rachel has the best service record. She worked 500 hours in 18, 19, and 20, but we don't have to count any of them. In 20, she was 250. But in any case, we don't have to count those because they're before 1/1/21. But she dutifully got 500 hours in 21, 22, and 23. So On December 31, 23, she's completed 3 12-month periods of 500 hours. She gets in 1/1/24. Monica, well, she had 10 hours in before 21. We don't care about. In 21, she had 10 hours. In 22, 500. 23, 500. 24, 500. So she would enter the plan on 1/1/25. Her third 12-month period ended on 12/31/24, so she gets in 1/1/25. Now let's take a look at Phoebe. Well, Phoebe's first year we care about is 21, 250, no, 250, no. 523, yes, 524, and 525. When does she enter? Well, Miss Phoebe gets the benefit of the Secure 2.0 change because as of 1/1/25, the plan must now allow entry to any long-term part-time employee who's completed at least 2 consecutive 12-month periods with at least 500 hours in each of them. And so Phoebe is getting in a year sooner than she would have as a result of Secure 2.0. And this is how it's going to play out across all the plans, that 2025 is going to be a banner year where the people in 24 complete 3 or 2 consecutive years will get in. Completing 2 by 2023 doesn't cut it because the new rules don't take effect until 25. So it's a little odd that they did it this way, but according to my friends at ASPA, they talked to staffers and this was their intentional. This is the way they expect it to work. If Central Perk decides to make a discretionary contribution for the 2024 plan year, do any of our waitresses need to share? The answer is no. How about for the 2025 plan year? Well, lo and behold, Rachel has entered the plan as a I take that back. Rachel should have been. I updated these slides to get the Phoebe in and the like. So Rachel in 2025 has already entered the plan. So she'll in 2024. So she'll get a contribution there. She'll also get one in 2025. None of the other employees would be eligible to share in the 2025 plan year because none of them have completed a year of service. Can it be more liberal and allow the long-term part-time employees to participate? The answer is yes. If so, how do the 401k testing, coverage, non-discrimination, top-heavy apply? And the plan may elect to exclude the employees who are eligible to participate solely on the basis of being a long-term part-time employee. May Central Perk permit part-time employees to get in earlier than 3 or 2 consecutive years? The answer is yes. As we said, that's a plan design alternative that might avoid these rules entirely. And that's the point. IRS guidance will be needed to confirm that, but I think it is certainly worth a shot. But hopefully, and let me add, the IRS is well aware that's an issue that needs to be resolved in the guidance they are working on. So it should be answered if and when we ever get this much awaited piece of proposed regulations is what we expect it to do. If they are permitted to share in employer discretionary profit sharing contributions, then what would be their vesting credit? Well, we're able to exclude service now before 2021. So Rachel gets her first year in the first year of 500 hours in 21. In 21, she's got 2 years of service. Therefore, it's a 6-year graded vesting. 20, 40, 60, 80. As far as Monica is concerned, she gets no credit for the 2021, it's less than 500. But then she starts up the path. And likewise for Phoebe, she's 0 and 500 and then goes 20, 40, and we'll see where she goes from there, depending on her later years. If Central Perk is a safe harbor plan, how do we treat the long-term part-time? We can give them contributions, but we don't have to. And if we provide for automatic enrollment, plan may, it's not clear if the plan must apply automatic enrollment to long-term part-time employees before the mandate takes effect. I think if it is a plan to which the auto enrollment mandate applies beginning in 25, then I think you will have to auto enroll long-term part-time employees. What if Central Perk has a second location in Brooklyn? And what we're getting at here is the same idea. If can you exclude the Brooklyn people and have that are long-term part-time employees, even if you have a plan for the Manhattan location? The answer is we need to find out from the IRS. I think you can. But if there is some service-related issues, such as to work in Manhattan, you had to first do 5 years in Brooklyn, then no, that's a service-related indirect service requirement and would not be permissible. All right, getting near the finish line, folks. Amendment deadlines. 1.0 had a remedial amendment period during which plans need to be operated in accordance with the new law, and then plan amendments will need to be adopted in the future to conform the plan document to the new law and any regulatory guidance. The Secure 2.0 has extended, the 1.0 deadline was extended by the IRS. It's now been extended by Congress. So 1.0 and 2.0, as well as the CARES Act, all have the same deadline until the end of the 2025 plan year to update for 1.0, 2.0, the CARES Act, and the Disaster Act was also in there as well. 2025 plan year, government and collectively bargained plans have until the end of 27. And again, operational compliance now, you need to keep track of exactly what you are doing. Limited guidance out there, folks. That's unfortunate. It should be remedied soon. I was very hopeful that we would have that guidance before I would do this webinar, but we need to get prepared. I can't emphasize enough that these rules are fast upon us. We're at the end of March. That means 9 months, and we will be admitting these people. But we have other questions. Can you use the equivalency method, where if you work 10 hours a day, if you work an hour in any day, you get 10 hours of credit, or an hour in any week, 45 hours, et cetera, et cetera. Can you do that? The answer is probably, but the safe harbor doesn't work with a long-term part-time employee who works 1 hour a day, typically doesn't work 10 hours that day. And it's a question of whether the IRS might amend those regulations on equivalencies, and or I guess it's the DOL regulations, I should say. And I wouldn't expect it anytime soon, so I wouldn't expect equivalency methods of counting will work very well for long-term part-time employees. Again, church and grandfather governmental 401k plans adopted before May 7th. Not clear whether they're exempt. Non-ERISA 403Bs are, but there was no specific grandfathering of governmental 401ks. Another concern is audits, because suddenly we're going to bring in all these new long-term part-time employees that are going to drive our participant count over 100 or 120 if you're in the 80-120 rule, requiring an independent audit accompany the Form 5500 filing. And I mean, that is a concern. Long-term part-time employees are participants. However, there is at least one There is an important change that will be effective for this reporting, the 5,500 for plan year 2023 that we're in. The active or the participant count for purposes of whether you file as a large plan and need an independent audit will be based on the number of participants with an account balance in the plan. So if a long-term part-time employee does not put any money into the plan as an elective deferral and does not otherwise receive a contribution, they will not go into your participant count for purposes of whether you're a large plan or not. And that's true across the board, but DOL specifically mentioned these long-term part-time rules as one of the reasons they were making that change. And it was finalized just a few weeks ago, and we can rely on that. Again, beginning with the 2024 plan year, or actually, the more I think about it, before the 2024 plan year, let people in to make elective contributions sooner, so this would avoid the long-term part-time rules entirely. You should be watching the IRS guidance that will be coming out. I'm sure it will be covered by ASPA, Benefits Link. I'm sure I'll do an article for our LinkedIn page. So look for something there, but that is a big question to be answered. And if the IRS agrees with what I think the right answer is, you may need to take some actions really before the beginning of the 2024 plan year. And I believe that gets us to the end. I apologize for a few typos. This has been a work in progress for months. And I wanted to bring you the latest stuff, and I'm human, so I will fix them. But hopefully it didn't detract too much from the presentation. And so, Yvette, do we have any questions?
We do. We have quite a few. So our first one is, what are pitfalls of changing ECP from shift to plan year to anniversary year method?
You know, I haven't, the main detriment to the anniversary date method has been the fact that you've now got 365 eligibility and vesting computation periods that in the old days made it more difficult to track. Given our software today, I don't think it's quite as onerous as it may have been years ago when we all, and I mean, given where the law is, it still makes sense to do it that way, but given the change in the law, it may be time to rethink it, and I think it would be advantageous because otherwise we may be tracking these, having different computation period rules for long-term versus full-time, and I'm not sure the regs even permit you to apply that rule differently to one group of participants versus another. Next question.
Alrighty. If you had a plan that excluded all highly compensated employees, could you then exclude anyone else?
You can exclude whoever else you want, but you cannot exclude long-term part-time employees who become eligible under these rules. So in other words, just because the plan doesn't cover highly compensated employees does not mean it's exempt from the long-term part-time employee rules. They will still have to enroll long-term part-time employees. Next.
Any educated guess on what definition of employee for purposes of 10 or fewer for exemption from auto enrollment?
That's a very good question. I mean, I think it's going to be the common law employee rules as to who is an employee. The question is, what's the computation period? When you go over the 10 employee limit, the new rules apply as of the beginning of the next year. For the exemption as a result of being in business 3 years or not, there is no clear statement as to when you will join the plan. But So I think it's just going to be your common law employee, and the real questions, and I think the question is well taken as to what does it mean, 10 or fewer, how many hours is it if they're on the payroll, and I think it's normally employ less than 10 employees per year.
Okay. For
Next question.
off-calendar year plans with eligibility computation period that switches to plan year, could they come in under long-term part-time in 2023 if they met the 3 consecutive years with 500 hours?
Repeat the early part of the question.
For off-calendar year plans with eligibility computation period that switches to plan year.
Okay, now that's what I just wanted to hear, that first part. Yeah, I think they could come in 2023 potentially. But, it begs the question of not having any guidance on how these rules will work, and it's an operational issue. The IRS, we have been begging them to get the guidance out. So I hope there will be some good faith application of these rules, but I think that's a very good question, and I think it's a distinct possibility. Next one.
All right. So in 2024, Rachel can't be excluded from testing, but Monica and Phoebe can be excluded.
In 2024, let me look. I've got, where did I put my charts? There it is. In 2024, okay, so Rachel's getting in. I mean, in 2024, Monica and Phoebe are both excludable employees. Rachel gets in the plan, but she can be excluded as by virtue of being in the plan solely on the basis of a long-term part-time employee. So none of them need to be included in testing in 2024. In 2025, Rachel would no longer be excludable because she would have completed a year's service in 2024 and therefore is a full-time participant beginning with the 2025 plan year. Next.
Do long-term part-time employees count toward audit requirements?
I answered that at the very end. The answer is yes, but if they have a zero account balance, no.
Okay, vesting long-term part-time 500 hours, however, full-time employees 1,000 hours?
The 500-hour rule applies to any employee who enters the plan solely because of their status as a long-term part-time employee. So if you work part-time for a year, and then the next year you go full-time, so you enter as a full-time employee, you're never going to be subject to the 500-hour rule. But if the reason you initially begin participation in the plan is because of being a long-term part-time employee solely on that basis, then the 500-hour rule applies for the rest of your employment history. Maybe one or two more.
All right, and this is our last one.
Oh, perfect.
All righty. I have a staffing company with a ton of long-term part-time employees.
Yeah.
If we add the long LTPT employees, I will put them into audit. It is currently an auto enrollment plan at 6%. If we auto enroll at 10%, maybe discourage enrollment.
Yeah. And that's actually one of the points I make when I'm talking about Secure 2.0 and automatic enrollment, is that you can begin the automatic enrollment. I think it's got to be at least 3% and then goes up, auto escalates till 10, but there's nothing that precludes you from starting at 10. And I would say there's nothing that precludes you from starting at 10 in automatic enrollment, but I think you got to do it across the board. And remember, those long-term part-time employees, yes, they will need to, well, the staffing plan likely, I assume, was established before, before December 29th, 2020. And so the question is, they're not probably subject to the automatic enrollment mandate, but you are going to be subject to long-term part-time employees. And if you've already got automatic enrollment at 3% and you think a way to discourage the long-term for signing up, go to 10, so be it. I think that might work, but keep in mind, you do have to give the long-term part-time employees the opportunity to make a different deferral election than that which is their automatic enrollment percentage. All right, folks, we have gotten right to 60 minutes on this webinar. I hope you enjoyed it. If you liked the webinar, great. If you didn't like it, the presenter's name was Robert Richter. Remember that, Robert Richter. Otherwise, keep an eye out. We'll be doing more of these on selected Secure 2.0 topics in the weeks and months ahead. And we certainly enjoy your participation. Yvette, take it away.
Awesome. Well, just a reminder to go ahead and fill out the survey at the end of this webinar. It will pop up once the session ends. This will allow us to track who will be needing a certificate. If you have any questions, you can email us at webinars@nova401k.com. To view any webinars you may have missed and the recording of this session, you can follow us on our YouTube channel, which is Nova 401k Associates, or you can visit our website, which is www.nova401k.com/webinars. Thank you, Craig, for your time today, and thanks again to everyone for joining. We hope you enjoy the rest of your day. Bye.
Bye, everybody.